Okay, well, thank you very much. Great to see you all here. I'm David Erdos. If you don't know me, I'm part of SIPL, and it's my very great pleasure to welcome Jill Phillips from The Guardian. Jill has tremendous experience of the whole media landscape and the information law landscape. She seems too nice, but she does actually have experience with News International, News Group, the now defunct News of the World, The Sun. She also has experience in the BBC, so public sector broadcasting. She is an alum of this esteemed university and indeed of this faculty. But much of her time, certainly in recent past, has been spent at The Guardian, so the sort of the quality broadsheets and how they approach legal and ethical issues to do with personal information, natural persons and people's information. And it's those issues that she's going to be concentrating today. As this is the first information law seminar, a note on our recording. So we are recording, but we're only going to put up Jill's talk. We don't put up the discussion that follows subsequent to that. So only Jill, in a sense, needs to beware, particularly for her talk. After that, we can have a freer discussion. So without any further ado, I'll pass over to Jill.
Thank you. Thanks very much, David. Yes, it's good to be back, although I do come back from time to time. As David said, I'm a qualified solicitor. I work in-house for The Guardian and Observer, and I've done that for the last 10 years or so. So I'm not an academic. I'm not going to stun you with highbrow, normative value type talks. It's going to be pragmatic and down to earth, because that's the environment that I work in. And I'm going to talk around some of the ethical, regulatory and legal restraints that govern what UK newspapers can publish. And the statute book's full of legislation that controls and constrains speech. There's a lot of civil law, defamation, privacy, personal data, some of which we'll touch on today. And there's also a lot of criminal law, obscenity, terrorism, official secrets, harassment. And I'm not going to touch on much of that side today, because that's not really going to impact on the natural person's sort of subject matter here. But I'm also going to look at how all that fits together and where the public interest fits into that landscape. And the background really to all this is that there's a constant battle for information. There always has been in different ways. And it's all about who can publish what, when, about who, and who's trying to stop that. And there's obviously going to be an area in the middle where people are going to disagree about what should and shouldn't be published. And the newspaper environment are obviously going to err on the side of free speech where they can, where they feel that they're able to. That might upset some people who may disagree with that. As I said, I'm talking about people. I'm not going to talk about companies or open court stuff, Article 6 stuff, which is another sort of part of the landscape that I operate in. And I'm also going to talk primarily about the ethical and legal framework within the UK. But I should emphasise that, you know, in this modern, global, interconnected technical world, we all now operate in a global legal environment as well. So, you know, long gone are the days when The Guardian published one newspaper a day that was primarily aimed at and bought by a UK audience that covered mainly UK news with some international news. Nowadays, The Guardian's publishing 24 hours a day, rolling news. It's got offices in New York, Washington, on the West Coast, Australia. And reporters, particularly these days, can file copy from anywhere in a matter of nanoseconds. That's back in the office. And so in theory, you know, we're subject to every law of every land, because following the case that you may all be aware of, Dow Jones and Gutnick, Australian High Court case from 2002, that case basically said that anywhere you can be downloaded, you can be sued. And there are various nuances around that, but that is the essential premise. So, you know, that's an occupational hazard, and the only way really realistically that we can operate practically is within the UK legal framework, which on the whole is more restrictive than most areas, or is in line with most areas. So it doesn't tend to cause us problems. But, we have been sued in Italy, in France, in Iran, in Zimbabwe. We've had regulatory action in France. It's a bigger picture than the one I'm going to sort of focus on today, just so that that's in the picture. So I just put this up because I like this quote, because it seems to me that in many ways it personifies what some of the problems with law is when you're looking at speech. Obviously, it was meant in a much wider context. So I'm going to talk about regulation, then I'm going to talk about some legal issues, defamation, privacy, data protection. I'm going to talk about something that I've called the homogenization of claims, because there's a coming together now of all these claims: defamation, misuse of private information, and data protection, in a way that is troubling for me, may not be for other people. I'll mention a few other random bits and pieces that we have to take account of. And then if I have time, I'll do a tiny little bit on how all this really practically manifests itself in a difficult area, which is reporting on criminal activity. And the quote that I put at the bottom there, which I'm quite happy David can get the slides off me or whatever, is a submission that was put into Leveson by the newspapers that's quite a good summary of the main bits of the law. It's quite neat and tidy and short. So if anyone wants a reference point, that's quite a good place to go. So starting with regulation, I put this slide up because some of it may seem pretty obvious, but point 3 there, the maintenance and enhancements of the standards of the output by review of its quality, really is indicative of where the regulatory framework sits within journalism. It's been accepted in that case, which was a Freedom of Information Act case, that standards and review of standards is part of the journalistic process. So it's not something that sort of stands outside it in that sense. And I guess the second question is, why does the press need regulating? And why worry about standards? And again, I'm just going to sum that up with a few choice quotes. So this is a rhyme that I always rather like: tickle the public, make them grin. The more you tickle, the more you'll win. Teach the public you'll never get rich. You'll live like a beggar and die in a ditch. Sort of sums up really why the tabloids sell as well as they do, and why quality papers like The Guardian and others struggle in terms of print circulation, at least. Another quote that sums up some of the issues: bad stuff put on the front pages, and you can't find any of the good stuff. And then there's this quote from David Broder from 1973. But what it says is really newspapers in the old days, the print newspaper, was always going to be something that was never going to be the finished work. It couldn't be the finished item. And although that's very true of that process, it's equally true today. It's just that there's an awful lot more information that can be fed into that process an awful lot more quickly. So it's a difficult environment to work within when you're trying to do your best, as certainly The Guardian would do, to get things right. But you'll all know that getting things right is a pretty subjective assessment in a lot of cases. There's a lot of room for argument. I think I just thought I'd do a very quick, and it will be very quick, run through of some of the history of regulation, because there's always been attempts to regulate the press, right back from the sort of Star Chamber days of Charles I, going through to the Long Parliament of Cromwell, and of course that produces Milton's sort of raging about licensing and how you shouldn't license things and you should leave them unlicensed, and that the truth and the falsities will argue against each other and truth will ultimately emerge from that process. That's essentially what he fought about. And until about 1690, the end of that century, there were licensing acts. The press was licensed. The 1662 Licensing of the Press Act, for preventing the frequent abuses in printing seditious, treasonable, and unlicensed books and pamphlets, and for regulating of printing and printing presses. And even when that goes, from about the early 1700s onwards, there's stamp duties, stamp taxes are applied to newspapers. It's another way of controlling them. And they have more impact on the popular press, which is cheaper because it's a cover price tax. So that impacts a lot on the lower end of the market, the popular end of the market. And again, those sort of stamp duty controls don't disappear until the mid-1800s. And over the rest of the time, there are various attempts to complain about the press. It's not something that's just a common modern phenomenon. It's always been there. And there were 3 royal commissions on the press, 1949, 1960 and 1974. And those were all prompted by what were seen as abuses from the press. So you end up at the end of the 1990s with cases like Gordon Kay. Do you know the Gordon Kay case? Where he was an actor, he was injured in when a plank came through the window of his car in a storm in the 1990s, and he had to go into hospital. He had serious head injuries, and a tabloid journalist went into the hospital, lied to the doctors, got an interview with him, and got some pictures of him. And he tried to stop them. And back at that time, the courts basically said, well, there's no cause of action. There was no privacy cause of action at that time, and there was just nothing he could do. He tried everything: libel, malicious falsehood, trespass, and the courts just said, you know, there's no remedy for you. And that prompted a wave of parliamentary action, none of which really got anywhere. Then we had Calcutta 1, that was 1990. David Mellor, the famous quote, drinking in the last chance saloon. Then 1991, the Press Complaints Commission replaces the old Press Council. Another batch of bills that don't go anywhere. 1993, you get Calcutta 2, which recommends statutory regulation. The Tory government doesn't want to do that. Then you get phone hacking, moving on through to the Leveson inquiry. And then you get to where we are today. Sorry, let me just get this, move the slides on. The sort of the current position, which is that we've got a series of regulators all doing slightly different things, all regulating slightly different areas, as well as organisations like my own, the FT, the Independent and Private Eye, self-regulating, not being part of any of these organisations. And then you've got Ofcom, which is regulating basically the broadcast media, and the mismatch, if you like, between online, broadcast, old print has never really been resolved. You might have thought that online might be regulated like a broadcaster were, particularly because everybody gets most of their information through a screen these days, and they're not really distinguishing a TV screen from a computer screen to a phone screen. It's all coming through that medium as opposed to print in the old-fashioned way. So, there's a lot of sort of regulatory confusion going around, and there are a lot of ethics codes floating around. And they're all slightly different, but they all cover the same sort of ground. The one thing most of them don't cover is social media. So that's left to sort of fend for itself or do what it wants to, depending on how you look at it. And when you're looking at the ethical issues that are covered by the codes, and this is really what the Guardian works within, these are all areas primarily that aren't covered by any law. So they're imposing, voluntarily or otherwise, higher standards or more standards on what's put out and how and why than you have to sort of abide by law. So this is just some of the main areas that are covered. Accuracy, and you'll see anyone who sort of knows anything about defamation, defamation's about accuracy, essentially. It's just that it has to be involving an individual, defaming that individual, but you can still have something that's inaccurate but not defamatory. And I've always seen that as a sort of scale thing. So as you move up the scale, you maybe have a relatively trivial complaint, you go to a regulator. If it's more serious, you can start looking at going to the courts. Privacy, likewise, is a regulatory issue, but now and it wasn't an issue 30 years ago when I started doing this sort of work. There wasn't any private, nobody worried about privacy at all, nor data protection. It's all come down the road and hit us slightly, or taken us slightly by surprise. Subterfuge, using covert filming, not telling someone you're a journalist when you're trying to get information out of them. All these sorts of things are covered by the code. Suicide, how you write about suicide, is not something that's a legal issue, but it is an ethical issue. There are guidance in the code about not revealing too much detail about how people commit suicide. There are issues about how you report sexual offences so that everybody reports them in the same way, to stop what they call jigsaw identification, so that otherwise you might have one paper, say in a case where a parent is involved, you might have one paper naming the parent, but talking vaguely about the offence, and the other way round, you might have someone talking a lot about the offence and not naming the parent. But if you were to read both of those, you'd be able to work out that it was a family issue, and therefore that the child was that child. So there are rules in the regulatory codes about how you deal with those sorts of things. There are a lot of sort of what I've said are new problems that aren't covered by codes. So hate speech, trolling, anonymity, the fact that people use anonymity, anything that I call UGC, which is user-generated comment below the line, stuff on websites, social media, political advertising. Very little of that is covered by these codes. Obviously, there's the ASA, the Advertising Standards Authority, that do advertising. But otherwise, all the stuff above my line there are ethical issues that voluntarily newspapers agree to follow. And for example, one of those issues is fairness. So David, just while I remember, I don't have a watch or a clock or anything.
I do.
So when I'm, just when you're getting bored or restless or whatever, just wave or something. But fairness is one issue that's covered by the Guardian's code. It's covered in our code as well as in some guidance that we've got that goes around the code, and that manifests itself really only in an opportunity to reply after publication. In terms of the code, and that's most codes are like that. They're a post-publication right for people. However, the Guardian's guidance quotes from C.P. Scott, who was one of the Guardian's eminent editors, from an essay that he wrote, and he said this: "The voice of opponents, no less than of friends, has a right to be heard. It is well to be frank, it's even better to be fair. The more serious the criticism or allegations, the greater the obligation to allow the subject the opportunity to respond." And that's always been interpreted as a pre-publication responsibility, i.e. before you write and publish an article that's going to be critical, you go to someone and you give them the opportunity to respond. Now that has a sort of legal corollary in the sense that under the Defamation Act, Section 4, which is a public interest offence, that's responsible journalism, that you go to someone. There's a very practical reason that you want to go to someone, because if you have got something wrong, you've got the wrong person, you've misunderstood something, that's the opportunity for that to come out. And if you don't do that journalistically, there's a risk that you've just, you've misspelt something, you've misunderstood something. So there's all sorts of reasons why you might want to go to people beforehand. It's what, I call the right to reply. And we spend quite a lot of our time as lawyers in the legal department at The Guardian, at any rate, discussing with journalists those letters that they're going to write before they publish anything, setting out the allegations, giving some detail about it, and saying to people, is this right? Have we got this right? Do you want to comment? Have we misunderstood something? There's usually quite a lot of aggressive responses back from highly paid external lawyers, but that's all part and parcel of the process that comes out of it. The other thing that sort of lurks in the background of this is that Strasbourg, over the years, has started talking about good faith journalism and uses good faith in a number of cases to talk about things, and sometimes says, well, a journalist's behaved responsibly in good faith, therefore we're more inclined to give them an Article 10 protection than we might do if they haven't done some of these things. So again, there's a legal underpinning to some of this sort of code stuff that has a benefit for the journalist if they behave in that way. So I'm going to sort of move on to the public interest because this is probably the best place to deal with it. And there's masses of academic articles I discovered on, what the public interest is and sort of philosophical discussions about how it fits in. I have to deal with pragmatic practicalities. So what I'm looking for when I'm trying to work out whether something is in the public interest or not is some hard stuff that helps people formulate their views. And there are bits and pieces scattered around. There's no definition particularly set in law. There are references in various of the codes, and I've just put in here in this slide the IPSO code has various things that are asterisked in it, which I've listed there. And basically that says subject to the public interest and allows you to sort of disapply or not follow the code if you think there's a public interest. So that's how some of the codes work. But public interest, as I say at the bottom there, is also relevant in defamation, in privacy, in confidentiality, and in data protection. So, for something that is so important and increasingly becoming important, it's sort of slightly curious that it isn't, in a way, better defined, although, again, from my perspective, I'd far rather it wasn't defined than stuck in some statute that is set in law that is then hard to argue against, however much they say, subject to these are the exceptions or whatever. It's never particularly satisfactory as opposed to just letting it be a holistic thing that can ebb and flow and weave with how society changes. And I think that's one of the main reasons why over the years Parliament's never enacted a privacy law, because essentially it's tied up with those sorts of subjective decisions. So this slide, I've just tried to put some of the key reference points down that I would use when I'm trying to have a discussion about public interest with the journalist. And ultimately, it's not my decision whether something's in the public interest. I can advise and discuss with the journalist, but it's for the journalists to make their own decision. As we see with data protection, it's their reasonable belief that something's in the public interest, not mine. But I can have a discussion with them. And there's some, the codes IPSO and Impress both have definitions of public interest. The Public Interest Disclosure Act, which is the Whistleblowing Acts of Employment Act, has a list of things that it deems to be in the public interest when people are whistleblowing. The CPS guidance has some very useful balancing discussion about how the public interest can fit or not, and some of the common themes that have been identified: preventing, detecting crime, protecting public health, putting the record straight, so if someone said something publicly and it's not true, or you think it's not true, there can be a public interest in trying to expose that, disclosing failures to do things, and then the one that's quite interesting, raising or contributing to a matter of public debate, including serious cases of impropriety, unethical conduct, or incompetence. One of the big issues that we've had over the last couple of years with some of these big data leaks, Paradise Papers and Panama Papers, a lot of those stories have really been about moral issues, ethical conduct. They're not about tax evasion. Most of them, they're about tax avoidance. And there's been quite a lot of attempts to say, well, that doesn't cross over the public interest threshold. I happen to disagree with that. I think there are big ethical issues. But when we were sued by Appleby in the litigation earlier this year, that was one of the arguments that was effectively being advanced. You're only talking about things that aren't illegal, so that's not a good enough public interest. So it's important. So that's my regulatory run through. Moving on to defamation, I'm not going to give you a lecture on the law of defamation. There are others who can do that better and in much more detail than me, but the key elements are this: making a false statement about a person to others, which lowers them in the eyes of the public, subjects them to ridicule. There's a whole load of standard phrases that are used, although whenever the courts get to try to decide them, they're all going, oh, well, I'm not sure whether it is. Anyone wants to read Burchill and Burkhoff, the courts there waver and come to completely different decisions about whether something's ridicule, whether it's comment, whether it's fact. So, if the Court of Appeal judges can't decide these things, the rest of us are just sort of mere mortals, are playing a sort of a subjective game as far as we can. Cause is likely to cause serious harm. This is the controversial sort of new element that was added by the Defamation Act 2013, and that is being discussed at the moment in the Supreme Court. Well, it was 2 days ago on appeal, where they're looking at what this serious harm test means. Now, when I'm talking about this to the journalists, I say it's really easy for someone to start a defamation act. That's all they've got to do. They've just got to say, you made a false statement about me, it's made everybody hate me, you published it, it's The Guardian, it's obvious, so I can bring a claim against you. And at that point, the burden of proof shifts to The Guardian. There's a presumption of falsity, effectively, and The Guardian has to then be in a position to prove the truth of what was written. And that's a discussion that you have to have. You can't just say, the journalists can't just come and say after the event when they're being threatened, oh, well, give me a couple of weeks, I'll find the evidence. You've got to have the evidence before you publish, or you should have the evidence before you publish. That feeds into the right of reply route that I mentioned earlier. And the big complication here is around meaning, because that's the starting point for any defamation. That's what I spend all my days doing, is looking at articles, going, what do they mean? What is the meaning here? And I'm trying to second guess in a way what a very suspicious claimant lawyer might think something meant, and trying to see whether I can ameliorate that, or whether I'm happy that the evidence that the journalist's got can support that meaning. And there are some sort of legal fictions around this single meaning rule. Effectively, there can only be one meaning for an article. Actually, that's not true in reality. People have all sorts of different meanings, but ultimately the courts will decide that there is one meaning, and that's the meaning that you can be left defending. So when I was at the Sunday Times, we did a long piece about Lance Armstrong and drugs, and he sued, and the court said this article means that there are strong grounds to suspect that he's guilty of taking drugs. Now, we had never meant that meaning when we wrote it. There was a lot of suspicious circumstantial evidence, and the thing that tipped the balance for the judges was that there was a quote in the article that said experts take the view that it's almost impossible for him to have done one of these hill climbs up the Alpe d'Huez hill without having some sort of drugs. And they said that quote from the expert tipped the balance into a much stronger suggestion of guilt. If it hadn't had that in it, it might have been a lower level meaning. And that was not a meaning that the Sunday Times were in a position to defend at that point. So they had to settle the case. Now, history shows that actually what they wrote was very true. And that's one of the frustrations sometimes being an in-house media lawyer, is that you and the journalist know something's true, but you also know that it's difficult to get the meaning and the evidence to balance out. And the quote at the bottom here is, it doesn't matter what the journalist intended, it doesn't matter what the publisher intended, it's what a court ultimately decides they mean, and that there can be a disparity between that. So it can be a tricky thing, and there's a test that's applied here, as understood by the hypothetical, ordinary, reasonable reader, whoever that might be in this day and age. There are some sort of characteristics that are ascribed to them. Fair-minded, doesn't read it like a lawyer, is not looking for the worst meaning, but blah, 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 blah. I mean, ultimately, this hypothetical, ordinary, reasonable reader turns out to be a judge who may not actually be anything like a hypothetical, ordinary, reasonable reader, because he's a lawyer, for starters. It used to be the case that meaning was decided by juries, but that's really gone by the by because there are no juries in most libel cases these days. So, it's a sort of strange approach. It's a artificial approach, but you need to have a meaning to move things on. And what's happened in defamation claims is that there's been this sort of level of meanings attributed, three tiers of gravity, and those are known as chase level meanings after a court case. And basically, chase level 1 means guilt, Chase level 2 is reasonable grounds or strong grounds to suspect, and chase level 3 is questions or something to investigate. Now, those grounds are really important in meaning because they relate to the evidence that you're allowed to rely on when you're trying to defend what you've written. So, for example, anything that is up in the top end of that, reasonable grounds to suspect or guilt, you have to have evidence that's effectively conduct of the person involved. If you're down the bottom end, you can be talking about circumstantial stuff. But when you publish the article, you've got to try and write it so that it's pitching at the right level. And if you get it wrong, as the Armstrong case showed, then you have a mismatch and you're going to lose. That's it, basically. So we spend an awful lot of our time, as I say, looking at meaning. Trying to write down. So for example, I quite often will change a word like liar to because lying suggests that you knowingly said an untruth. It was in your head, you had intent. That's really difficult to prove in a lot of cases. Just because something turns out to be wrong down the line doesn't mean that someone was lying when they said it. So you can still say that they said this and it turned out to be wrong without saying they're a liar, i.e. that they deliberately were trying to pull the wool over people's eyes. So, there's little nuances that the lawyers and, good journalists can write in stories that make them legally safer, less risky. And there's a lot of that we sort of operate within. Just moving on to some of the defences that are relevant and that, again, we have to take account of when we're looking at what we publish. Truth, you'd have thought, would be, an easy winner. But as I say, and as I've mentioned already, because of the burden of proof and meaning and the disparity that can sometimes hit with evidence, it's not as straightforward as journalists think. And there's a rule called the repetition rule. Anybody know what the repetition rule is? Basically, you can't just repeat what someone else has said. But it's not just what someone else has said. You can't just say X was arrested and prove that they were arrested in order to win. You have to prove the underlying meaning of arrest, which is that there are reasonable grounds to suspect that they've committed an offence of some sort, or whatever the appropriate test is. And you may have no idea about that. So there's quite a lot of risk. Other jurisdictions are much more straightforward on meaning. If you wrote someone had been arrested in France, all you'd have to do is prove that they had been arrested. But we have this very complicated, nuanced law around meaning, which makes it quite hard work, as I say. Honest opinion is another thing that, a lot of the Guardian comment is free, is relying on honest opinion as its defence. But honest opinion has some legal elements to it. And in particular, you have to have some factual basis for it. So, if you go to a restaurant and have a terrible meal, you can't just say, this meal was the worst meal I ever ate. It was poisonous and I was sick afterwards. If you write that sort of thing, it's going to be quite dodgy unless you've said because the food was uncooked or because it seemed to be unclean, or you need to have some facts in there. And there have been a couple of cases of, I think, theatre reviews where people reviewed things without actually going to see them. And, you're not going to get away with an honest opinion type defence on that sort of thing. And we had one recently where someone had reviewed a video game that actually they hadn't looked at. And so they got a few things wrong. So that was a slam dunk on the complaint on that one. I've just put at the bottom various reporting privileges around fair and accurate. I'm not going to dwell on those. I'll just dwell a bit more on opinion. Because, opinion's where a lot of things are fought these days. It's where a lot of people object to what's written. But if it's opinion, generally speaking, as long as it's got some factual basis and it's genuinely believed, people can say what they like, subject to parameters around hate speech. That's probably the only thing. So, I've put 3 things down here. I think Jones is a liar because that's clear comment. That's clear opinion. If you believe the prosecution, Jones must be lying. A bit more cuspy, but it's still, I think, opinion. The evidence demonstrates that Jones is a liar is fact. And you've got a completely different set of rules if you get sued as to what you're going to have to prove depending on how you phrased your statement. So that's just a sort of simple way of trying to say how it all plays out. The third defence that I wanted to just touch on is a relatively new defence in terms of statute, Section 4 of the Defamation Act 2013, but this builds on an old common law case which is mentioned right down the bottom in subclause 6, which is the Reynolds defence. And that's essentially a responsible journalism defence. That's trying to do the best you can before you publish. And that again goes back to the right to reply that I mentioned earlier. And in the Reynolds case, which was a case from 1999, I think, against Times newspapers, Lord Nichol laid out 10 matters that he said, non-exhaustive, you should think about when you're looking at whether someone's behaved responsibly. That includes the tone in which you write the piece. Now, you can imagine tone for The Guardian's not a difficult thing. Tone for The Sun or The Mirror or the Star is a much harder thing because just of the way that they sell their stuff and write their stuff much shorter. It's much more brutal in that sense. So tone's not a great one for them. There's a lot of stuff about the sourcing of the information, what you've done to check it, but it doesn't necessarily matter that you've got it wrong. That's the thing about this defence. It's a defence that allows you to get things wrong, providing you've gone about it in the right way. And there are quite a lot of people who don't like that. Jonathan Code, particularly, has written about how it's not compatible with various Article 8 issues because it effectively allows you to publish things that are untrue, that are generally going to be personal information. If you know something's wrong, why should you have a defence to it? Now, the way it works is you shouldn't know it's wrong when you publish it, but subsequently it may turn out to be wrong. And this gives you a defence. That works very well in print when you've got a one-off publication. When something's online, if you've got something online, there's a case called Flood and the Times newspapers, which is about an online complaint. And in that case, they'd got some sourcing from the police about an investigation into Gary Flood, who was a policeman. They published the article. It then turned out there was an internal report later that effectively exonerated him. And there was a big issue about what happened about that online article. And ultimately the court said, well, once you have definitive evidence that something that you wrote was wrong, even if you're protected up until that time, because at the time you had a Reynolds Section 4 defence, going forward, you've got to do something about that. And most newspapers would, in that situation, put a footnote or something on the top, depending on how serious it was, to say, since this article was published, this report has exonerated X or Y. And again, some people don't think that goes far enough. Newspapers would say, well, it was right when we published it at the time. We had no reason not to. You shouldn't start interfering with archives, the integrity of archives, with newspaper reports. They're sitting in the archives at Colindale or wherever they are now, on some old microfiche going back, hundreds of years. So it's a tricky area getting the balance of that. Moving on to the next one, misuse of private information. Again, historically, English common law didn't recognise any privacy law, and I mentioned the Kay and Robertson case earlier. And in that case, he brought claims for libel, malicious falsehood, trespass to the person passing off. The Court of Appeal said none of these torts was applicable except malicious falsehood, and the only remedy there was to stop the newspaper from publishing anything that inferred that he'd consented to the publication of the article about him. And that caused a great deal of stir. And then you move on, 1998/2000, Human Rights Act comes in, Article 8, as well as Article 10, becomes part of English law in a much more direct way, even though it's always sat there behind the scenes. And you get cases like Sarah Cox and the People, which was pictures of her taken on the beach on a honeymoon. She went to the regulator, won that, and on the back of winning it before the regulator, then went to law, and the case settled pretty quickly. She got £50,000 from the People out of that. And then you move on to, Naomi Campbell and the Mirror, where the Mirror said, where the court said basically, okay, the text of this story about Naomi Campbell going and visiting a Narcotics Anonymous meeting, the text of it was probably okay, balancing privacy, because she'd made certain public statements about what she did and didn't do with drugs. But they said the use of pictures showing her going into this meeting tip the balance. So pictures start becoming a problem in some areas, even if text alone isn't. So again, that makes, that's made automatically from 2004, privacy starting to creep up and make life much more complicated than it was, because up until that point, really all I would be worried about as a lawyer was, do we have the evidence to prove the meaning that we might get sued for in defamation? That was the main focus. Now you're sort of looking at this different balancing act that you're having to do, and public interest is creeping more and more into the equation. Even if something's true, if it's private, you've got a potential problem, and you've got to start making some harder decisions. And then from Naomi Campbell, you move through Von Hanover, Douglas and Hello, Max Mosley, and what happens with those cases is the law of privacy gets more and more defined. The courts accept effectively that there is a tort of misuse of private information, and what they also start doing is awarding higher and higher damages for breaches. So you go from the early cases, I think in Naomi Campbell, she got £2,500 damages for the pictures. You go forward to the phone hacking cases, the civil cases in against the Mirror, particularly Galati is the case, 2015. Alan Yuentob got 85,000, Paul Gascoigne got 78,000, and Sadie Frost got 182,000. That's a collective award for the phone hacking intrusion, the publication of a number of articles. But, the risk for the newspaper, because of the financial damages award, obviously, again, is another shift in the balance. If you were only going to get fined £2,500, you might take a risk. If you're starting to look at a possible damages award of 250,000, you're going to start thinking again about, sensible risk analysis. Lawyers will think about how they play all that out. So, and where this gets us to really is a position where there's this test, the reasonable expectation of privacy test, which is what we're all the lawyers in-house, that's where, on all these cases, even if something's true, we're asking, well, even if it's true, what's the privacy situation in this information? Is there a private issue here? Where's it come from? What does it relate to? And what's happened, and I've got some slides at the end on this, is that effectively there is now a balancing act that has to be done between Article 8 and Article 10. So Article 8 of the European Convention, private rights, Article 10, freedom of speech, and it's a balance between those two rights. They're competing rights, and you have to look at some of these different things again in terms of deciding whether there's a reasonable expectation of privacy, not defined anywhere. I've tried to put on this slide some of the cases where they've discussed some of the things that you might look at when you're deciding. So location, Campbell, as I said, was her going into the Narcotics Anonymous building. That was considered to be pretty much a private act. Murray and Express is J.K. Rowling's son. He was just in a pushchair on the pavement going to a cafe, but that was considered that he, as a child, had a reasonable expectation of privacy. Rock and Roll v. NGN is, I can't remember who he is. He's someone's husband. They're all cases that the nature of the activity. Again, Campbell going to visit Narcotics Anonymous. Spellman, again, I can't remember which one that is. But they're all building up these different situations where they're saying there's a reasonable expectation of privacy, where you might not necessarily think there was, or you might not think that it was something you had to worry about. So again, 5 years ago, 10 years ago, would I worry about a picture of a street with cars parked or people walking up and down it? No, I wouldn't. Would I worry about pictures of people's front doors, as long as there wasn't a defamatory slur attached to it? No, I wouldn't. Nowadays, yes, all the time. Children, all the time. Hospitals, all the time. These are all things that have shifted and have made it much harder to decide, what you use and how you use it. And in terms of categories of information: children, high risk; photographs, high risk; anything that's relating to people's home or family life; sex, particularly, slightly weirdly; body health stuff, personal relationships. All those things are areas that you need to really start identifying whether there's a public interest if you're going to go down that route and start talking about them. And there are shifts in these things. If someone's a celebrity and they've been making very public statements about things, most celebrities these days send out notes all the time saying, this baby's just been born. I'm not going to do anything with them. You're not allowed to have any sort of rights. And you see these rather stupid visual pictures of the celebrities with a face of a baby blanked out or whatever it is. It's slightly weird, but it's because everybody's worrying that someone's going to bring a sort of J.K. Rowling type case over a 3-month baby, month-old baby, or whatever it might be. So they're just not going to go down that route, which is sort of just a big shift from even a few years ago. So that's private information, privacy. And then we've got David's favourite subject, data protection, my least favourite subject, which again just sort of came down the line and rather hit us all over the head. And, the thing about this is, again, personal data is this enormously wide set of stuff. You sort of start thinking, well, it's a name. And it's not just a name, it's a postcode and an email address and a recording of things and a photograph, and anything that leads into identifying a living individual is potentially problematic. And then you've got that. Then you've got these special categories of personal data. Anything that really reveals racial or ethnic origin, political opinions. I mean, on one hand, that would mean you can publish anything that the politicians say in court, because that's special high-end personal data. It's just ridiculous. And there's trade union membership. Does that mean you couldn't say that Jeremy Corbyn is a trade union supporter, or as a member of this union, or whatever it might be? There's some very, ridiculous things that you can sort of build into this. David will argue about this with me later. And the most ridiculous one, I think, from my perspective, is the last one, criminal activities, which covers everything from people being arrested through to convictions. It's supposed to be sensitive personal data, which means in theory it's got a much higher level of protection. And yet, newspapers over the years have had protections from open court reporting for defamation and contempt. And now this has come down the line, sort of running that way, sort of going, no, you can't report things that are said in open court. And nobody's really got to grips with how all that fits together, practically speaking. So it's a difficult landscape, and there are these data protection principles which also then feed into this. The main one of which there's various of them that can play out in this, but the main one is accuracy. And if ultimately what we're talking about is accuracy in defamation terms, then that's going to feed directly into a conflict between data protection and defamation. And I've just put down the bottom, right to be forgotten, which I'll mention again, but I'm not going to dwell on because it's another whole nightmare. There is a journalistic exemption in the Data Protection Act, the new one, and in the GDPR, which says personal data which are processed for the special purposes, which includes journalism, are exempt. And then there's this sort of quite complicated set of conditions. If the processing is being carried out with a view to the publication of journalistic material, so does that mean if you aren't intending to publish straight away that you can't do it? If you're doing what journalists do all the time, which is gather information and hoard it somewhere in a box, waiting for this person to suddenly be held up for something, and they go, oh yes, I know, I've got this about them from somewhere. You're not allowed to do that journalistically anymore. The data controller, whoever that may be, query whether that's the journalist who's doing the publication, reasonably believes that publication of the journalistic material would be in the public interest. Most organisations, the data controller is actually either the company, it's not even an actual person, or it's someone high up on a sort of, a raft over there that's got nothing to do with the publication of the stories. It'll be a commercial lawyer or someone like that. You're going to have to discuss with them every time you publish something, so that they're satisfied, or can you rely on the journalist's view that it's in the public interest? And then you've still got to say that even with all that, you've still got to think that the things that you're not allowed to do are incompatible with these special purposes. So it's quite a complicated scenario to try and analyse when you're just looking at whether you can publish a story or not, and you're trying to do so quite quickly. There's some ICO guidance on this which relates to the old Data Protection Act. The ICO is supposed to be doing some new guidance, but I don't know what's happened to that. That guidance is sort of useful, but actually, like on photographs, it does the easy stuff. It talks about crowd scenes, which is sort of easy because you think, yeah, there are clearly privacy issues in this, but it doesn't really go into some of the more difficult things about whether you can put a picture of someone in a story that you're writing about them, or where maybe they're not the main person, but they're a peripheral part of the story. Can you use a picture of this person? It's a tricky one, and we get people saying, no, you can't and you shouldn't. And there are all sorts of sort of guidance on, again, a balancing act that you have to apply here about what you can and can't do. There are different set of criteria to the privacy ones and the reasonable expectation of privacy. So you've got these sort of overlapping, but also with edges with margins, if you like, that don't overlap, that you've got to try and think about with privacy and data protection that can make it quite tricky. And right to be forgotten, yeah, I'm not going to talk about because that's another nightmare. So homogenization of claims. And what I really just wanted to do is just sort of do a couple of things, which is there's been a shift. Claimants, ultimately, the person who complains can decide their cause of action. We can't set the cause of action. So a claimant can decide to sue us for privacy rather than defamation. Even though once upon a time it would have obviously been a defamatory remark, there's quite a lot of areas of overlap, as we'll see, where they can choose. So when they choose privacy, the defence for us on privacy is a public interest one. That's it, basically. Whereas if they sue us in defamation, there's a truth defence. There's a slightly differently nuanced Section 4 responsible journalism defence. But they're not necessarily the same. And what's happened in Europe is that the shift from defamation to privacy, whereby what's happened is the right to the protection of reputation, which isn't featured in Article 8 at all, isn't mentioned in Article 8, and indeed was deliberately not put in Article 8, whereas it was in the original UN Charter. It originally appeared and still does appear in Article 10.2. So it wasn't a standalone right, the right to protection. It was an Article 10.1, Article 10.2 balance. Now what's happened is, in Europe, there have been a lot of cases, and these are just some of them, where reputation has become an Article 8 right, a privacy right. And what that has meant is that that you've got two competing rights. So instead of having an Article 10.1 and an Article 10.2 argument, what you've got now is an Article 8, Article 10 argument, even in a defamation case, where you're going, what's Article 8 got to do with the defamation case? It hasn't got anything to do with it. It now has got things to do with it, and that means that your analysis of this is different. There's a shift in what you have to look at, in the decisions you have to make. And what's also happened is that in Article 8 and Article 10, these cases, Axel Springer and von Hanover, set out some rules that you apply in an Article 8, Article 10 proper argument, a proper privacy argument. And those criteria fit very uneasily if you're actually trying to defend what's really a defamation article. So it's become a very complicated landscape, and this is the case re S that sort of sets out how you have to do these balancing acts. The Terry case, which is at the bottom of that slide there, is one where I don't know if I set out the details. Yes. So in Terry, Tugendhat, who was the judge in Terry, this is John Terry. It's a privacy injunction case. He identified 4 classes of case where there was a possible overlap between privacy and defamation, and these are the 4 put sort of briefly. Class 1, he said, actually there was no overlap. Information is not defamatory. So Douglas and Hello, Murray, it's a pure privacy act. There's nothing nasty written about anyone. And that's governed by that route. An overlap which is historic, where under old defamation law there used to be some sort of slander of if you accuse someone of having an infectious disease or of doing certain things, don't dismiss those. Third case, overlap but no inconsistency. Cases where the information relates to conduct which is voluntary. This comes back to the defamation rules about conduct, and alleged to be seriously unlawful, even if it's personal. And then the fourth category, which is cases where the complainant complains about information that is both private and discreditable, but says it's false. And these are the cases where once upon a time you'd have been sued for defamation. Now we're being sued not for defamation, but for privacy. And so we have to have a completely different set of sort of defences and arguments in place and analysis before we publish than we might have done 10 years ago. And that's quite tricky. And you're getting to a stage where truth is becoming irrelevant, because in privacy cases, truth's just not one of the things that's particularly argued about. It's private information, whether it's true or false has a little bit of argument around it. But, you know, that for me, journalistically, that's worrying, that the fact that you write something that's true can still ultimately end up not being published. And that's an enormous shift from 30 years ago in where the legal balance sat in these things. And this is also happening in data protection, because claimants are using data protection, not defamation, where information's inaccurate, because there's no threshold, so there's no serious harm. The Le Show case that I mentioned earlier, there's nothing like that in a data protection case. There's no limitation period. In most defamation cases, there's a 1-year limitation period. You don't need to show any actual damage. You can bring a claim just for distress. And again, the public interest is what is the trump card here, not truth. And there's this case, Prince Moulay against Elaf Publishing, where the court said there's no reason in principle why a data protection claim could not be linked to a defamation claim. If an article was not defamatory of Prince, then he should be entitled to an alternative means of redress via the DPA. Could see no good reason of principle why a claim under the DPA cannot be linked to a defamation claim, and why it should not be added by amendment. So in this case, in the Elaf case, there was an argument about whether something was defamatory, and it looked like it might be struck out as not being defamatory. So the claimant then said, "Oh well, we'll add in a data protection claim," and the defendant said, "Well, that's just not fair. You started off down this route, and now you've lost there, and now you're going off there. That's an abuse." No, said the court, it's not an abuse. So, and I just saw yesterday that case has now been settled, presumably because they're going, well, we've got no defence to a Data Protection Act claim. So, that's all just, as I say, difficult, tricky areas of judgment that we're having to make when we do things. These are just some of the other things that float around legally in terms of the framework. Malicious falsehood, prior notification, do you go to people beforehand? Harassment, there's other cases on harassment, trespass, copyright. All these are things that we're looking at and thinking about, just checking whether they're there before anything's published. And then finally, as I said, just wanted to touch on where all this seems to sort of reflect these things that I've mentioned on reporting criminal activity. This is the final slide, you'll be pleased to know. So again, once upon a time, you just would not worry as a newspaper about publishing stuff about people being convicted. You had open court privileges around that. If you were publishing things about people under investigation, your worry would have been defamation. Because if you say someone is being investigated by the police, there's a meaning, probably low level if you've written it carefully, questions to ask. So you'd be worrying about defamation. You wouldn't be worrying about anything else. Now, all these things are being dealt with under privacy and data protection. So again, the truth is irrelevant to all this. And so there's been a whole little series of cases in the last couple of years where things that you used to think were okay are now not okay, and newspapers are getting injuncted and prevented from publishing or publishing and being sued for. Obviously, the most famous one, Cliff Richard. Cliff Richard, that case 10 years ago would have been a defamation claim. He'd have argued that and possibly a bit of privacy depending on timing. But he would basically have been saying, look, you've done a massive story about me being searched. That implies that I've done something wrong, and that's where that battleground would have been fought. Now it's not being fought on those sort of bases at all. I don't think that defamation entered the Cliff Richard BBC case. Arrest, again, the Sun was prevented from reporting a billionaire's arrest on suspicion of rape. The police have got the College of Policing Guidelines on Media Relations 2017. Police will not name those arrested or suspected of a crime, save in exceptional circumstances. That's an enormous shift from not so long ago, where you always used to know the name of the person arrested. And that, not naming them on arrest, is creeping down the line towards charge. There are some people that say you shouldn't be able to name anyone until they've been through the court process of being convicted. I'm not here to judge the rights and wrongs of that, but that is an enormous tectonic shift from what was done. If you look back at the old News of the World on a Sunday, or the Sunday Express, and the Telegraph indeed, they were full of court reports. That's what they did. So you've got statutory protections for certain sorts of court reporting, fair and accurate contemporaneous reporting, and this is where the right to be forgotten is coming in from the side, because even though you had a protection at the time, 2 years down the line, people are now coming and saying, right to be forgotten, this is all past, water under the bridge, you can't maintain that article in your archive anymore. And then old convictions, there's a big argument around where spent convictions fit in, and that's a privacy issue, and it's also a data protection issue, because data protection says it's sensitive personal data. So that's it. That's the legal framework. And as I say, it's shifted a lot over the years. So, sorry.
Well.